member for Warringah.
Speaker, it is critical that the Australian public can trust that our democratic institutions are working properly, and they need to be sure that they are independent, impartial and free from politics. If you have an administrative decision that you feel has been wrongly decided and needs to be challenged, then the tribunal, the Administrative Appeals Tribunal, was the place of recourse. And so if that system is not working fairly, we have a situation where you cannot challenge the decisions. The new review body proposed under this legislation, the Administrative Appeals Tribunal, will, under the provisions of this legislation, be more transparent, more accountable, and more importantly, will have an appointment process that cannot be overtly tainted by political appointments. Whether it's your visa application being denied or your NDIS application being rejected, or that you're subject to an unfair or adverse small business taxation decision, these are the types of matters this tribunal deals with. So this matters to everyone. And decisions on child support, citizenship, social security, freedom of information, immigration, security assessments, veterans affairs, workers' compensation. The list is long in why an administrative tribunal, appeals tribunal, is incredibly important. So decisions on these issues will affect people's lives and livelihoods. Now, the AAT, the Administrative Appeals Tribunal, was meant to be the body empowered to review the merits of those types of decisions. However, for too long, it failed to do the job properly. There remains 66,131 cases before the AAT awaiting finalisation. Most of these cases, some 83%, were in the Migration and Refugee Division. This has led to untold harm and distress to many, many people. The long-awaited bill is this bill to form the Administrative Appeals Tribunal. This long-awaited bill is an opportunity to fix the serious problems with the AAT. This set of bills will abolish the Administrative Appeals Tribunal and replace it with a new, much-improved Administrative Review Tribunal. Australians must feel that they will get a fair hearing by an administrative review body that can make key decisions affecting people's lives. So many communities, including mine of Warringah, are crying out for reforms to integrity in public life and administrative bodies. Now, the most high-profile, case or issue of late that has been dealt with by Administrative Review Tribunal was, in fact, Robodebt. And it's incredibly sad to think that whilst Robodebt made an adverse finding in relation, whilst the AAT made an adverse finding in relation to Robodebt being unlawful back in 2017, that was never published. And so it took another 2 years of more victims and more trauma and distress before the federal court was able to highlight and get a successful challenge to Robodebt. I've got to say it's disappointing to hear the Coalition's debate and argument on this bill, in that they still fail to acknowledge that responsibility of such a failed program, and that really you can't come to this debate looking for or discussing the question of an appeals body, an administrative appeals body that will work, without acknowledging the errors and the problems that we've had in the past, but also acknowledging where government gets it wrong and the importance where government gets it wrong, or where departments and administrative decisions get it wrong, that there must be a process of clear review, a clear process of appeal. So the question of who are the decision maker under a body becomes incredibly important. And there's clear evidence that for too long it's been overtly politicised. Research by the Australian Institute shows that under the previous 9 years of the Coalition government, some political appointments averaged 32%. And what was concerning was that in a number of instances we had appointments of people that did not even have legal training or expertise, that were just completely unsuited to really sit or determine the administrative review process. We know under previous governments, in the Howard era or under even the Rudd-Gillard-Rudd era, percentage of political appointees were there as well, but they were not to the same extent. It says clearly it was identified by the previous government as being a system that could essentially be abused to get political outcomes and really tarnish this process. There was a blatant jobs for mate process in the scheme, and it was directly infecting the ability of the AAT to function. In 2018, Mike Seacombe from the Saturday paper did an investigative piece that showed how far the rot had spread. In the 2018 annual report on the AAT, something that would usually make for quite ordinary reading, he actually noted that in the 2017-2018, the number of cases lodged with the tribunal reporting period increased dramatically, while the number of cases dealt with fell. So the numbers reported at the time were staggering, and yet the government of the day did nothing about it. It looked the other way when it was its responsibility to ensure there is an administrative review process that is robust and working. The annual report noted that the AAT faced an enormous backlog of appeals, dating back some 4 years, and that the total number of applications in front of them had grown to over 53,000 cases as at 30 June 2018. Speaking to the Saturday paper in 2018, the former AAT members said, There was really big spill of old experienced members and the introduction of people who, in some cases, were not interviewed at all by the panel set up to consider appointments. There was a process of appointments of people which was jobs for mates but not suitability for the job. The ruin of the AAT was done very much by that appointment process. It purged experienced people and expertise within the tribunal, totally abandoned any pretense of merit-based appointments and stacked it with political mates. So some of those political appointments, including party members, donors, failed candidates, retired politicians, although not all, at times lacked incredibly relevant experience to even do the job they were appointed to do. So the legacy of mismanagement, it still continues today, unfortunately. The most recent annual report from the AAT shows that they have finalised 61% of applications within 12 months, below the performance measure target of 75%. Now, I do acknowledge that the government has put more resourcing to tackle this backlog, but the mismanagement under the previous government will take some further time to clean up. And the government is doing the right thing, and I very much support the abolishing of the Administrative Appeals Tribunal. The previous government did its level best to essentially destroy the AAT and the functioning review body from within and for its purpose. And it's incredibly important for the Australian public to understand the essential role it plays for all of you. At some point in time, you may need to have an administrative review or appeal. So, the bill before us establishes the Administrative Review Tribunal, and it abolishes the Administrative Appeals Tribunal. When introducing the bill last year, the Attorney-General noted the aims of the new Administrative Review Tribunal will be in the essence of an independent body of review for federal decisions that is fair, just, timely and accessible to those who need it. So, and most importantly, the bill aims, by establishing a new framework for the Administrative Review Tribunal, to improve public trust and confidence in a key democratic institution and bring greater transparency to the quality of government decision-making. So, some of the bill will mean that the key features of the Administrative Review Tribunal will include a simple membership structure with clear qualification requirements and role descriptions for members of the tribunal. And I repeat that, clear qualification requirements, that those people making decisions must be qualified to do the job. Clearly defined roles and responsibilities for those who hold leadership positions within the tribunal. A transparent and merit-based appointment process for members of the ART, and I will come back to that in a moment, allowing the President of the ART to manage the performance, conduct and professional development of its members. A suite of powers and procedures allowing the tribunal to respond flexibly to changing caseloads, mechanisms to identify, escalate and report on systemic issues in administrative decision-making, and the re-establishment of the Administrative Review Council, and finally, the abolition of the Immigration Assessment Authority. So I want to thank all those, especially out with our communities and in organisations, who have made the time to make submissions on this bill. Many of those submissions have noted the bill lays out a solid framework to improve the current appeal review process. However, there are still some shortcomings that will require remedy and which I know the government is actively considering. Firstly, it is a question of the independence of making merit-based appointments, and that can be strengthened. I know the member for Mackellar has proposed amendments to do exactly this, to ensure the use of assessment panels in the appointment process, make sure it is mandated, and require that the minister make appointments from these panels shortlisted candidates. And note that there has been discussions with the government in this respect, and I certainly hope and expect that the government will introduce amendments themselves at the consideration in detail stage. Of course, in cases where a suitable candidate can't be found through the process, then the minister is required to table a statement of reasons in any case where an appointment is made against panel advice, a merit-based process. We must get to that merit-based process and explanations as to departures of recommendation. These amendments will ensure that political cronyism and jobs for mates culture, which we saw under the old Administrative Appeals Tribunal, can be a thing of the past. Another omission of this bill is the statutory review clause, and so I have proposed an amendment to that effect in relation to providing a statutory review provision, because we have to be realistic and make sure that we review this to make sure it works as intended. Again, I note discussions with the Attorney-General and his team and thank his office for their engagement and note that whilst I have an amendment that I've proposed for consideration in detail, that there may well be progress from the Attorney-General's office himself. The previous AAT had fallen into such a depth of disrepute that a statutory review of its replacement must be made at a reasonable interval to ensure that the same mistakes are not made again. The public has a right to know whether or not the ART is functioning as intended, free from political manipulation. I acknowledge, finally, the reinstatement of the Administrative Review Council will provide an internal review mechanism to ensure that best practice is followed and that the quality of decision-making by the ART is of a high standard given the effect it has on so many lives. Nevertheless, an independent external statutory review process is essential. Finally, public confidence in our institutions is vital for their legitimacy. I thank the Attorney-General and his office for hearing many of us from the crossbench on proposed amendments. I will be supporting this bill. This is an important piece of legislation and the biggest reform of our system of federal decision-making in some time. I urge the government to consider constructive amendments, as I've said, put forward around these final areas that can be improved. We need to make sure that people's lives are not upended or frustrated through an inadequate review system of administrative decisions, as has been the case for too long. We saw through the debacle of Robodebt the incredible level of harm that poor administrative decision-making and government decisions can make. There must be a review process that is robust and that is fair, that is independent of political persuasion or of political influence. The Australian public must be able to have confidence that they can bring an appeal to an administrative decision and have a fair hearing. I commend the bill to the House.